Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review. Thank you for listening. Here's Beth Mulcahy.
Welcome to our neighborhood services partnership with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. Our class today is going to be, you have been recently elected to the board of directors. What do you do now? In this class, we will be covering the roles, responsibilities, risks, and fiduciary duties of board members in an HOA or condo. My name is Beth Mulcahy, and I am the managing partner and senior attorney for the Mulcahy Law Firm in Phoenix, Arizona. I have enjoyed working with and representing HOAs and condominiums for over 27 years. My firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. Today, what we're going to be talking about is charting your course. And we're going to be talking about a comprehensive guide to board roles and responsibilities in an HOA or a condo. And for those of you who are just joining us, welcome to class number 5 of our firm's 2024 Virtual HOA and Condo Academy. We teach these classes in partnership with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. So we're going to be launching 2 polls right now. If you're joining us on Facebook Live, what I would like you to do is just answer the question in the comment section, please, so we know that you're there. If you're joining us on Zoom, you're going to be seeing the poll on your screen. So the questions are, in what city do you reside? And the second question is, what is your current role with the association? Are you a board member, community manager, an interested homeowner, or other? So while we're waiting for those poll results to come in, we're going to talk a little bit about what's on our agenda today. And then also we're going to talk a little bit about the new legislation that's pending in the Arizona legislature. As always, at the end of our class today, I'm going to be doing a free Q&A. So we encourage you to submit your questions via the Q&A box on Zoom or the comment section on Facebook Live. And we promise to answer every question during this session today. Please, however, limit to 1 question per person, since it looks like we have a great turnout today, 123 people, which is amazing. So we do ask that you just limit it to 1 question per person, and please try your best to be as specific as possible with your question, because it's hard for me to follow up with you when we're doing a live virtual format if I need clarification on the question. We're going to go forward and talk a little bit about our legislature. Our legislature has been in session since January 8th, and we've been closely following the bills that pertain to associations. This year, there were many bills introduced, over 20. Some of them were a little bit duplicative of the same topic, but we already have 7 bills that have been signed into law by the governor that pertain to HOAs and condominiums. So from my perspective, I would say this has been a very big legislative year for associations in Arizona. As you may know, the legislature is still in session. This has been kind of a year of hot topics in the legislature other than HOAs and condos. We anticipate that the legislative session should end hopefully in the next few weeks. After the legislative session ends, 90 days after that is when all the new bills that are signed into law by the governor go into effect. So we have plenty of time to analyze and talk about these 7 bills. And if anything's added before the legislative session ends, there may be more than 7. We do have a summary sheet that we put together that we're going to be sharing with you right now on those 7 bills that have passed and been signed into law this year. Again, these won't go into effect until 90 days after the legislative session ends. So when we get closer to the legislative session ending and the effective date of these new laws, we'll be having a special seminar just on this topic to talk about the bills and how they're going to impact your communities. And they may impact your board, how you're managing things as a board in your community. We're going to be sharing with you now the 2024 legislative summary. We also update frequently on our website what's going on in the legislature. On our homepage, we have the legislative summary posted, and we are updating it frequently throughout the legislative session. We have over 136 people here today, either on Facebook or on Zoom. Okay, let's shift gears now and talk a little bit about our focus of today's presentation. So charting your course, a comprehensive guide to serving on your board and your roles and responsibilities of being a board member in an HOA or a condo. In this class, we're going to talk a little bit about the roles, the responsibilities, the risks, and fiduciary duties of board members in an HOA and condo. Let's just start out with a question that I commonly get from boards is, hey, do I have any liability if I'm serving on this board, especially the new board members? So let's say you've just been elected to your board and you're wondering, or maybe your spouse is saying to you, like, hey, I know this is like a volunteer thing, but like, hey, can this like impact our financials in any way? So let's get that elephant in the room discussed right away. When you're serving on your board of directors, there's many layers of insulation for you as a board member. So you are never going to be held personally liable for anything that happens on your time on the board. Now, there's some exceptions to that. Like, let's say you embezzled money from the association. That would be an exception where you would be personally liable for that. But, 99.99999% of the time, when you're serving on your board, you have no individual liability. So that's important for you to know. Let's say that you get sued as a board member. Let's say that you have a homeowner that sues the association and maybe names the board individually in the lawsuit. What does that mean for you individually? Well, there's plenty of insulation around you as a board member. The first layer of insulation is the association should be carrying directors and officers insurance. They call it D&O insurance or E&O insurance, errors and omissions insurance. And so that layer of insulation protects the board for your decisions that you make while you're serving on the board. And if for some reason the board is sued or the association is sued for the board's actions or individuals are sued, you are going to have the insurance company will be notified and the insurance company will tender defense, hire a lawyer to defend you in this matter. And you'll pay no out-of-pocket cost individually. In terms of serving on the board, really important for you to know that you don't have individual liability. You have insurance coverage under your D&O policy, your directors and officers policy, to provide insulation in the event that you're sued. And then the third layer of insulation is under the law and under your documents. Typically, this is also in your bylaws of your association. The association is required to indemnify you as a board member in the event that you are named in a lawsuit or there's a judgment entered against you for your service on the board. So lots of insulation for you as you're serving on the board. So take that worry, off your plate. It's challenging to be a board member. I think at the introduction to this class today, I talked about the fact that I am a board member in my community and have been for many years. And we were less than a quorum. Don't worry, we weren't violating the open meeting law. But we were just kind of talking about some of the challenges that each of us are facing, serving on the board and where we saw things going this year on some of these bigger challenges. And, it was nice to have a connection with another board member because honestly, I've been feeling a little frustrated about how things are going. And just to share that, hey, we just need to reprioritize. Hey, we don't have the votes to do some big things that we wanted to do this year. And just strategizing about reprioritizing on what are some things we think we have the votes on the board to accomplish this year. So just a starting point, serving on the board can be very rewarding because many times I'm walking around my community at night when I'm walking our dog. And I think about the many things that we've accomplished and I'm proud of that we've done. But it also can be frustrating. So I think that's important for everybody to hear who's sitting on this call who are board members, 73% of you. It's okay to feel frustrated about your time on the board. That's actually kind of normal because you're dealing with problems, right? Maintenance, once you fix one thing that, everything's going to be honky-dory in your association. That's not how it works, right? Once you fix one thing, another thing breaks. It's just like home ownership, right? And so there's constant maintenance. You're going to have problems with people, right? There's going to be personality conflicts. There's going to be people who are upset that they received a violation letter. These are all things that happen when you are serving on a board. And, both of those could be perceived as, potentially negative things. But the positives, far outweigh the negatives in that, hey, you're making a difference in your community. You're solving a lot of problems. You're planning for the future. You're fixing things that need to be fixed so that amenities can be used. And you're helping people, basically. And it's free. You're doing it for free. You're not getting paid. You're doing it because you love your community and you want to see it better. So as we, kind of navigate into, I like to kind of hit those two topics first, like, hey, you don't have any liability. You have plenty of insulation around you as a person serving on a nonprofit board. Second, it's hard to be a board member, and there are many rewards for being a board member, but it also has a lot of challenges, and that's normal. And you have to have kind of the one thing I would say is if you're serving on your board, you have to have a sense of humor, because if you don't, it's going to be a very long term that you're serving on the board. You have to be able to look at things and be able to laugh at times, because there are some things that happen that are funny and kind of, just absurd. And you just have to laugh at it and say, okay, this is kind of funny. Let's move forward. Let's be able to laugh at the situation and be nice and move forward. Okay, so now let's dig into what it means to be on the board. What are your duties and responsibilities? So some of you may be on this call today and you may be seasoned board members looking for some sharp fine tuning and sharpening of your pencil as you're serving on board. Maybe you were just elected to your board in January or February this year, and you want to know more about, okay, what does it mean for me to be a board member? What are my responsibilities and duties under the law and under the documents? And so what we're going to do is we're going to give you just an overview of what are the different things that I think you need to know. The first thing I think that's really important is kind of the human aspect of serving on a board. So when you're elected to your board, you are looked at in the community as somebody who is a leader. And it's your responsibility to provide the caring leadership and service that makes living in an association desirable. So you're overseeing what might be the largest asset of many owners who live in your association. You have to understand that when people come to the meeting and they're fired up about something, it's because, hey, I have a lot of money tied up in this property, and I pay my monthly dues or my monthly assessments. And it's frustrating to me to come to the pool, right, and have it not be working, or the jacuzzi not, being heated, or whatever the issue is that you're dealing with. So just recognize that, you need to be we call it a servant leader in business circles, right? You are doing this because you love your community. You're serving, and you should be providing caring leadership and having a patient and kind approach in how you're handling homeowners and problems as they arise in your community. You have to run your association like a business. Okay. What does that mean? That means we talked a little bit about being professional in your interactions with owners, right? We shouldn't be ever having board members shouting at homeowners in a board meeting, or raising their voice towards each other, using bad language, losing your temper. All of these are things that are not desirable qualities of a board member. What we're looking for is somebody who is professional, responsible, respectful, nice, a problem solver that can look at a difficult problem and be rational and reasonable in how they approach finding a solution to the problem. I think probably everybody on this Zoom call has been in a situation where maybe you were frustrated about something, right? And so people come to you when they're at their breaking point in terms of being frustrated, and they may be behaving in a way that's not the way that they always behave. They might be upset about their neighbor that's having wild parties, or about the VRBO that, is running bachelorette parties, and it's, they're staying up all night and doing crazy things. And so you have to understand that people come to you sometimes in an agitated state, and you have to just be nice and listen to what they're saying. Let them know that they're being heard, and then try to proactively find a solution with them. Some other things that I think are really important are following the law. And honestly, I probably don't even have to say it for the 145 plus of you who are here today, because you're here because you want to learn what the law is, right? So that you make sure you're not screwing up and violating the law. There's Arizona laws that you need to be aware of. There's federal laws that you need to be aware of. Going to these classes is a really good idea, so that you have a general knowledge of, okay, hey, we need to know that if somebody makes a records request, it's an owner, that we have to provide the records of the association to them with a few exceptions, etc. Going to these classes, getting education, really important. But then you also have a heightened level of, okay, we have to follow the law too. So we need to be aware of it, but then we also need to follow Arizona and federal laws. And, a good thing to think about as you're navigating this, and you obviously also have to follow your association's documents. Make sure that you have your trusted advisors in place to help you navigate your time on the board. So this is going to be your management company, if you have one, your attorney, your reserve specialist for your association, your insurance agent. All of these different people are your landscaper. All of these different people are part of your team to help you comply with the law or help you do your job better. Having those trusted advisors in place is really important component of being successful on your time on the board. Okay, now let's talk about like some general responsibilities of serving on the board. Board members and directors are responsible first to participate, right? I can't tell you how many times I hear from boards this question. Hey, we have somebody who is elected to the board and they never show up. They don't come to board meetings. They don't respond to any telephone calls or emails that we may send to them asking them what's going on. If you volunteer to be on the board or if you're elected to be on your board, you have to participate. And what does that mean? That means attending board meetings, arriving on time at the board meetings, being knowledgeable and prepared for that board meeting, and being ready to discuss and vote on issues in the community. You also kind of have to have your antenna up at all times. Let's say you're walking around the neighborhood and you happen to see something that's a dangerous condition. You should be notifying your board or your management company of that dangerous condition so it can be rectified. Just participating, show up, be prepared, and have your antenna up when you're, walking around the community. What I am saying is, be the board member that if you see the gate at the pool broken and the gate now isn't locking properly, that's something that should be reported right away. Or maybe you see somebody doing something dangerous in the common areas, that should be reported right away. Maintenance issues, those type of things should be reported right away. Okay, another responsibility, general responsibility of the board is reading, understanding, and being in compliance with the association's governing document. By governing documents, I am referring to the CC&Rs, or the Declaration of Covenants, Conditions, and Restrictions, the Articles of Incorporation, the bylaws, and the rules and regulations of the association, the architectural guidelines or design review guidelines. These are your association's core documents. Now, when I say read and understand them and be in compliance in them, what I recommend is that maybe at the beginning of each year or once a year, you take a 15-minute spin through them. And everybody who's on your board should have a binder with all of the documents in it. You should have something, online, a resource that the board can use so that they can look things up at any time if they need to see the documents of the association. So just spend 15 minutes going through them once a year. Get the lay of the land, figure out, okay, the CC&Rs are going to be the use restrictions and that we have to carry insurance and that they have to pay assessments. The bylaws, those are going to be more of your how to run the association or how to run the board for your association. The Articles of Incorporation set you up as a nonprofit corporation and puts a shield around your board and your association so that none of you are held individually liable. So just doing the quick spin once a year, get the lay of the land on the documents. That is something that is a responsibility of the board. So that if a shed question comes up, okay, shed, use restriction, that's going to be in the CC&Rs. Can people have sheds or not have sheds, right? You just want to have a general working knowledge of the documents. Okay, let's talk about the next general responsibility. This is probably the most important thing I'm going to talk about today, and that is your fiduciary duty to the corporation. So when you're serving on the board for your community, you have a fiduciary obligation that's set up under the law that says that you have to have, basically 3 duties. So you have a duty of care, a duty of confidentiality, and then a duty to avoid conflicts of interest or self-dealing. So let's talk about those fiduciary duties just very quickly. And again, this is really important because it's something that every decision that you're making in your community should be based on this fiduciary duty model. Over, the 30,000 feet view of fiduciary duty is we need to be acting in the best interests of the association, right? In every decision we make as a board, that's our fiduciary duty. A more microscopic look at this would be, okay, we have the duty of care. What does that mean? That means when we're making decisions for the community that we need to research things and have information, get enough bids so that we make sure we're paying the going rate. Understand, the ins and outs of putting in the EV charging stations in our common areas. If you're looking into that, is there a rebate? How long will it take to charge? Just doing your duty of care when you're making decisions, right? The duty of confidentiality is obvious, but you have to keep things that you hear about in executive session or other sensitive things quiet, meaning you can only talk about them with the board. And, you can't talk about them with your spouse. You can't talk about them with your pickleball group, your walking group, your, water aerobics group. You can't. You can only talk about executive sessions and other sensitive items with the board. Be really careful on that because we see a lot of situations where there are loose lips and they do sink ships. You have to be careful. You're going to get the juicy scoop on everything when you serve on your board. And honestly, you don't even know that. When you get elected to the board, you're just like, whoa, this is like a lot of confidential information that's coming my way. Maybe it's about an owner's and a domestic dispute, or maybe somebody's not paying their dues or assessments. Or maybe somebody, we've received a complaint about a house being like a drug dealing house. These are confidential things that you need to keep confidential, and you can only talk about them with the board and no one else. The last fiduciary duty is the duty to avoid conflicts of interest and self-dealing. And this one's kind of obvious. We really do not see this hardly ever, but it's important to note is that you have a responsibility when you're serving on your board to not profit personally from being a board member, right? Or not have your family members profit from you being on the board. So, for example, no kickbacks from vendors should ever be directed to you. No special favors should be directed towards you. You shouldn't be hiring your nephew's company to be the landscaper. These are all potentially conflicts of interest and self-dealing, and it's against the law. Quick recap on fiduciary duty. You have to act in the best interest of the association, number one. Number two, you have a duty of care, a duty of confidentiality, and a duty to avoid conflicts of interest or self-dealing. Let's talk a little bit about one aspect that's kind of related to fiduciary duty that I think is just important that I mention as a caveat, is that when you're serving on your board, you have to place your interests secondary to the interests of what's best for the community. Let's say that your association is in dire straits, difficulties right now, and you need to have a special assessment, a large special assessment per owner to dig out of some of the problems that you have. Maybe you've got a big problem in a lake that you're responsible for maintaining in your association, right? And it's going to cost $1 million to fix it, right? And that means everybody's going to have to pay pursuant to a special assessment to pay for that if you don't have the money allocated in your reserve. And maybe you're thinking as a homeowner, I don't live near the lake. I don't go to the lake. Why do I have to pay for it? Well, that's just part of being on the board and being a member in the association. And so while you may personally not benefit from something, it's still something, an amenity that needs to be repaired in the association. And, maybe you're thinking, I don't have enough money or I can't pay a special assessment, so I'm just going to vote against this for the board. Well, that may not be what's in the best interest of the community. It may be in your best interest because you don't have to come up with the money, but it's, potentially breaching your fiduciary duty to the corporation. So you need to be really careful to place the interests of the association above your personal interests when you're making decisions as a board member. Let's switch gears and talk about a couple other important general responsibilities. Running the association like a business, right? Overseeing and treating the association's services and facilities as a business. So making sure that you're complying with city code or county codes that may apply to your association. Hiring licensed and bonded contractors is a huge one. There's a reason why you do that, and it's to limit your liability for the corporation, number one. Number two, to get somebody in to do the work who has the experience and expertise to do the work. And it's important that, you're thinking about the community, like you want to treat it like a business, right? You're overseeing a business. So you shouldn't be making short-sighted decisions, that are going to potentially have some pretty serious consequences for the association. Really good example I have of this is we've seen cases where an association may hire a vendor to do work in the association. And in one particular instance, I can think of a time that an association hired a vendor and the vendor was unlicensed and unbonded, and they knew that, but they were getting a cheaper rate, right? The vendor unfortunately got injured, seriously injured on the property while working. And ultimately, the association ended up paying like 10x more because this vendor fell off the roof of an association. And then the next thing we knew, that the vendor was in the hospital and had accumulating hospital bills. And the next thing we knew, we were getting a workers' compensation claim for this particular vendor who, we never thought he was our employee. But according to the state, because he wasn't licensed, he wasn't bonded, and he wasn't set up as an independent contractor, he didn't have insurance. Guess what? He technically was our employee. And so this particular association had to pay out a lot of money in, workers' compensation to make that person whole. When you're doing big projects, make sure you're running those contracts by your attorney. Make sure you're using licensed and bonded contractors and treating the association's business like a business. Okay, another responsibility would be if you have a management company, you have to oversee them a little bit. Now, there's a fine line here because there's a difference between, nitpicking and micromanaging them and not doing anything and just letting them do whatever they want as a management company. There's a balance. So you want to be somewhere, right in the middle on that. And so what's an example of how do we oversee the management company? And they have a very important role, right? Because they're overseeing banking, they're overseeing our budget, our insurance, making sure our insurance is getting paid, maybe any insurance claims they're overseeing. They keep our utilities on by paying the bills. They oversee the landscaper. They kind of are handling a lot of the business affairs of the association, like paying taxes. And so what's the good balance on this? Well, first, the point guard, of course, is going to be the president of the association, and they're going to be the person that probably has the most contact with the management company. But everybody on the board should be involved in, making sure that the management company is, doing what they're supposed to be doing under the management contract. Now, that doesn't mean that, one board member should be, going around the community with a clipboard, pointing out all the deficiencies in the management company and then, making their life miserable. I'm not saying that, but I am saying that, we can't just delegate everything to the management company and just check out. We should be looking very closely at the management company report in the packet that we get every month for the board meeting, making sure that they're accomplishing tasks that we've asked them to do or to look into. The treasurer should be very carefully analyzing the financials of the association to make sure that there isn't any sort of fraud or embezzlement going on, via the management company. Just making sure that we're making the management company aware of any problems or deficiencies on the property as we're using the facilities or as we're walking our dogs at night, just keeping them up to speed on what's going on and any maintenance items that need to be done. So basically, we need to oversee the management company pursuant to the contract, but we don't want to micromanage them to the point that they want to quit. It's just a balance. You got to, get in that sweet spot, a good zone, and, work together with them because they are your teammate, right? They're helping you with your time on the board, and it shouldn't be a negative relationship. It should be a positive teamwork type relationship. Okay, let's talk a little bit about Arizona law. One in particular that I want you to be aware of is the Arizona open meeting law. And basically what that says, and this is just a general responsibility, but this is probably, other than fiduciary duty, this is really important. The second most important thing I'm going to say today. Arizona has a special law that pertains just to HOAs and condos, and it's the open meeting law. And it says anytime a quorum of the board is meeting to discuss association business, we have to give 48 hours notice to the membership of the meeting. And we have to have an agenda for people who show up at the meeting. And we can only talk about certain topics in the open meeting. It's basically everything. except for some topics that if we want to, we can go into executive session. And those typical topics would be like advice from your attorney. Maybe if you're having a problem with a vendor or an independent contractor or an employee, you can do all of that in executive session. Now, mind you, before you go into executive session, you have to provide the owners with information about which topics under the law you're going to be discussing in executive session. That's the law. We have to do that. So you just need to be aware of, if we go into executive session, what we recommend is that you have the executive session meeting notice indicate which section under the law you're going to be discussing in executive session. And the reason why that's out there is because sometimes people felt that boards were going into executive session and talking about non-executive session topics. And so the legislature wants to hold the board's feet to the fire and say, okay, if you want to go into executive session, you need to provide notice to the membership which sections under the law you're going to be discussing during executive session. So just being aware that there is an open meeting law. We have to be very careful with email between board members. If a quorum of the board is emailing each other and making decisions, that's a violation of the law. And so the open meeting law is something that you have to comply with. And is it a hassle? Yes. But the benefits outweigh the hassle, because we want our homeowners to feel that we're being transparent and accountable. And the best way to do that is to give them the opportunity to participate and listen in on our open board meetings. Another aspect of the law that, want you to be aware of is you're going to see violations when you're serving on your board, right? You're going to have owners that aren't maintaining their lot, or, maybe they have a dog that's barking, or maybe they damage the common areas or something. One of the things that you are able to do under the law, if there is a violation of the documents by an owner, is fine the owner. But there are some special requirements under the law that we want you to be made aware of. First, you have to give the owner notice and an opportunity to be heard. So notice of the violation and then a hearing, basically. And the hearing doesn't have to be in person. It could be, you have a right to respond by email to this violation. And then the board determines whether or not they're going to levy a fine. So it's kind of a 3-step process. You send out the violation notice, right? And you say in the violation notice, you violated the documents in this way. And if want due process, or you want to have the board hear your side on this, you're welcome to respond in writing by email by, May 30th or whatever the date is. And then after that time period is up, then the board discusses, are we going to fine this person as we stated in the first letter, or are we going to not fine them because they corrected it or whatever? So it's a 3-step process. So notice of the violation, telling them about an opportunity to be heard, the actual time period for the opportunity to be heard, and then the board makes the decision as to whether or not you're going to fine them for what the violation is. So just being aware that there's a whole process if you want to fine an owner. Fines are kind of complicated in that you can levy fines against an owner, but in order to get them to pay them, you have to go to court and get a judgment. And, that's what the law says. In order to collect on a fine and make it a judgment lien, you have to perfect it by going to justice court, getting a judgment, which is a piece of paper saying Johnny Appleseed owes the association $5,000 in fines. And then you can collect it by garnishment of the owner's wages or their bank account. Another thing that we want to talk about, another responsibility under the law that I want you to be aware of, is if owners want to inspect books and records of the association, generally speaking, they are able to do that. So how it works is if somebody makes a request to inspect the books and records of the association, we have 10 business days to get the records to them, and we can charge 15 cents per page if the owner wants to see a copy of it. One thing I always advise boards is be transparent. If somebody wants to see records, let them. Because if it looks like we're trying to hide something, they're going to think that we're hiding something and we can't be trusted. The only exception to that would be is if we're involved in litigation, or I've given a legal opinion about a legal matter that I may not want the entire community to see. Another, general responsibility for the board is being a good communicator. What I always tell boards is the boards that have the fewest problems, guess what? They're the best communicators. And so providing open communication to the membership, such as like having a newsletter, a bulletin board, a website, a constant contact email that goes out, once a week, just updating the membership about what's going on. If there's a problem, if there's a big problem, what do we do? Do we bury it? Hope it goes away? No, we hit it head on. Recently, I had a situation where we had some homeowners in a community that were very upset about an issue. And I mean, this is not an isolated incident, right? I've been doing this 27 and a half years. And so, there's going to be times where you may have homeowners that are fired up about something, upset. And if people are genuinely upset and it's starting to, spread, call a town hall meeting, air grievances, say you're sorry as a board. Okay, we're sorry. We should have communicated better with you. And we're sorry for the situation, but we will do better going forward. Listen to the owners because they may have valuable feedback that can help you serve on your time on the board. By having a town hall, it shows people that you want to be transparent and that you want to do the right thing. Okay, another responsibility is having a budget for your community and then sticking to the budget. So we're in May of 2024, probably this summer, late summer. As a board, you're going to be talking about the 2025 budget. And for those of you who may be aware, we have some wonderful cheat sheets that we prepared. I know that we've already shared with you probably the board member cheat sheet that I'm teaching this class off of. But we have a great cheat sheet on budgets, right? So keep that in your back pocket. And in August or September, when you're thinking about preparing your budget for 2025, get that cheat sheet out and take a look at it. You will want to make good decisions about the numbers because ultimately you're setting yourself up for success. So that cheat sheet can give you good advice about, do we need to increase our assessments? How do we do it, et cetera? And how do we prepare a good budget so the numbers are accurate so we don't have a shortfall and not have enough money in the middle of the year? Another really great thing that boards should be doing is have a reserve study done. A reserve study is kind of like you hire a third-party contractor to come in and prepare it for you, somebody that has experience, maybe has a special designation or license to do reserve studies. But basically, that's a great planning tool for your association to plan for how long your amenities and other common areas, how much more useful life do they have? And it helps you put away money every year so that the end of the useful life of the tennis courts, we have enough money reserved for that in our reserve account to resurface the tennis courts. So it's just a great planning tool that I think is an important responsibility or, something that can help you fulfill your responsibility to maintain the common areas. Having a reserve study is a really great idea because it helps you plan out the future. Another important thing that you need to be aware of under the law is you do have to have your financial records of your association audited or reviewed or a compilation done every year. And so we're kind of in that phase right now, right? So we're looking at the 2023 books. And by June 30th of 2024, you need to have the audit review or compilation done of your association's 2023 books. Now, remember, you don't have to have an audit done by a CPA unless you're required that. So if your documents say that you have to have an audit done by a CPA, probably would be in your bylaws, then guess what? You have to do it, even though it's expensive and even though you may not have the money for it. Most associations don't have that requirement to have an audit done by a CPA. And so you can have the compilation or review done by basically anybody. Of course, you don't want the fox guarding the hen house, right? So you want to have an independent third party with some experience doing the review or the compilation. Another important responsibility of serving on the board is making sure your association has insurance and the required insurance under your documents and state law. We have a great cheat sheet on insurance that I would encourage you to take a look at. Also, look at the insurance provisions in your documents because they're going to give you a good feel for what the requirements are. Another thing that I think is really important is have a relationship with your insurance agent. Invite them to a Zoom board meeting and have them, just give a quick little 5-minute presentation. Why is that important? Because when something bad happens, you are going to need your insurance company to help you, right? If you have to make an insurance claim or you have a bad storm and a huge tree blows into the common areas and knocks over the association's clubhouse or gazebo or something like that. Or maybe a big lawsuit is filed against you by an owner. And what you don't want to have happen is you don't want to get 1-800 1-800 by your insurance agent, right? Just say, oh, call a 1-800 number and make the claim. No. What you want is you already want to have that relationship with the insurance agent, and you call them and you say, hey, we got this claim in. What do you suggest we do? Because sometimes the claim really shouldn't be made. Let's give an example. Let's say the damage on something is $4,000 to fix for the association, and you have a deductible of $10,000. Well, it doesn't make sense to make a claim on that, right? Because it's less than the deductible. You'd have to pay 10 grand to get 4 grand. That doesn't make sense. So, get to know your agent, invite them once a year to a board meeting, ask questions, ask if they have any suggestions for your association. Ditto on your attorney for your association. Your attorney is a very important part of your community, and you want to have a good relationship with your attorney and be able to pick up the phone, and they know who you are. They're not going to give you to one of their 25 associates who has never met you and doesn't know anything about your association. You want to have that relationship with them so that when there's a problem, they take your call. They understand what issues your community is facing and is here as a trusted advisor to help you continue to be successful and to stay out of lawsuits and follow the law. And that kind of goes with, another thing that we're going to talk about is the annual meeting. Every year, your association is required by law to have an annual meeting. That is really your time to shine as a board, meaning that this volunteer job that you put so much time in, most people don't come to regular board meetings, but you typically get a higher percentage of people coming to the annual meeting each year. So you really want to have great preparation for the annual meeting. You want to get things out early in terms of the notice or the request for candidates, and then the notice of the meeting and the ballot. And then when people show up, you want it to be very professional in terms of the meeting starts on time, and you maybe have some refreshments, and the board says what their accomplishments are, and they also talk about their challenges and how we plan to overcome them. The management company's there, they're introduced, they give a little presentation. Maybe you have a guest speaker like the police chief or your lawyer or politician. You want to plan it all out really well. And we have a cheat sheet that can help you if you're in this situation of planning your annual meeting and you want some suggestions. Check out our cheat sheet. You can find that on our website at mulcahylawfirm.com. And we have a special one just on the annual meetings. Okay, a few more topics on your board member roles and responsibilities. So number one, every year you have to file an annual report with the Arizona Corporation Commission for your association. You don't want to miss doing that. Okay, why? Because if you don't file your annual report over a period of a couple of years, no annual report being filed, what happens is that corporate shield around the board will go away because you'll become defunct as a corporation. Individual owners will be liable for the debts of the association, which we do not want to have. So a little bit of homework after this class here today would be for you to go to the Arizona Corporation Commission website. And the way to do that, just go to Google, type in Arizona Corporation Commission. And then on the homepage, you should click on the button that says something like look up information on a corporation. Type in your association's name and check to see if you're in good standing. If you're not in good standing, you need to reach out to your trusted advisors, your management company, or your attorney and fix that. And that form needs to be filed every single year. And there's a nominal fee that goes with, filing the annual report form, but you have to do it every year. And it's really important. It's easy to do. It takes 2 minutes to do. But the importance of it is really significant because it gives you that corporate shield around your association. Another box checker thing that's important is you have to file state and federal taxes annually as an association. You are required to, it's due on March 15th because you're a business and you have to file state and federal taxes. It's honestly just a form. You probably will have your CPA do it for you, but it shouldn't be a big expense to do, right? If you're a planned community, you have to pay property taxes. So you want to make sure that your association is paying them. Usually it's nominal because there's a law that values the common areas at $500 per parcel and allows you to combine them into one parcel for tax purposes. But just kind of a thing to remember is, okay, we have to have, if we're a planned community, we have to make sure that we're paying those taxes every year. Usually most associations break them up and pay them, over 2 different points each year, but it's just something that you need to be aware of. Another final thing that I want to talk about is the Corporate Transparency Act. This is a federal law that was signed into law by the federal government, and it's right now it's the law. I hope it doesn't stay the law forever, but basically this law was passed and went into effect January 1st, 2024. And compliance with the law starts January 1st, 2025. It's kind of a crazy law. Basically, what it says is that, it was passed by the United States Congress because they want to prevent money laundering and trafficking of terrorist activity, etc. I don't know how the associations as nonprofit corporations got dragged into complying with this law, but we did. It applies to all nonprofit corporations and for-profit associations with some exceptions. I mean, I'm doing a broad brush here on it, but we have to comply with it. And we have to provide contact information for the association directors and, additional information regarding corporation. And the compliance starts January 1st, 2024. So what I've been telling our clients is, okay, there's already been one court somewhere in the Southeast that has already deemed this law unconstitutional. And I think we need the dominoes to start falling this summer and into the fall. And it's possible that the legislature, the U.S. Congress may, fine tune this law to carve out associations. I know that the national chapter of CAI is doing everything possible to try to, make it so that we're not needing to comply with this law. But okay, here's the bottom line. As of right now, you still have to comply with it. There's companies that are doing this for HOAs and condos, national companies, they're doing it for HOAs and condos and other corporations. It may be something you're going to want to look into having them do it for you, starting in October or November. But stay tuned because it might be something that we don't have to comply with after all. But just keep that on your radar that, okay, hey, we've got to think about this Corporate Transparency Act. It's due January 1st, 2025. And we need to keep an eye on whether or not this law will be changed and it won't apply to us. Okay, last piece of parting advice would be have a professional and approachable manner and business-like decision-making when you're serving on the board. It's hard because I've probably been to, between my career and all the board meetings that I've been to over 14 years for my association, I've probably been to like 15,000 board meetings in 27 years. And I've seen just about everything. And the best advice I can give you is be transparent as a board. Communicate with your owners often as a board. Be approachable. Be businesslike in how you handle your business transactions. Follow the law, right? Follow state law, follow federal law. Go to classes like this so that you are continuing to get education so that you make sure that you're following the laws and handling things correctly. Make sure that you have relationships with your trusted advisors, right? Your management company, your lawyer, your insurance agent, your reserve specialist. All these are people who are here to help you. And really last but not least, don't forget about your fiduciary duty to the corporation. Duty of care, duty of confidentiality, duty to avoid conflicts of interest. These are all just really important tips for you as you're serving on your board. And I encourage you, go back and look at this cheat sheet. Check out our website. We have a wealth of free information for anybody on how to run your association, comply with Arizona law, comply with federal laws. We have over 80 videos that have received over, 85,000 views on a lot of different topics pertaining to associations. So take a spin through our website, look at our helpful videos, look at our cheat sheets as you're navigating your time on the board. Come to these seminars on live so that you can have your questions answered live. We're going to be sharing 2 cheat sheets with you, and then I'm going to get right into the questions today. One is on amending association documents and implementing rental restrictions. Summertime is always a great time to get caught up on projects like, hey, do we want to amend our CC&Rs? And this summer especially is going to be important because we have a new law that says that associations will be able to amend their CC&Rs to remove any unlawful provisions. So this summer would be a great time to do that, to get that ready for when the effective date of the new law comes in. You wouldn't even need to get homeowner approval to replace unlawful provisions. We also have a great cheat sheet on federal laws and community association records and documents. You can find all of those on our website. Last but not least, we're going to talk a little bit about code of conduct for boards. So we have a great cheat sheet on that. Got any problems with board members that, are problematic, not following the documents, being difficult? Whip out this code of conduct cheat sheet to help you navigate that problem. Okay, one last thing I'm going to mention is how to handle board member burnout. I'll be honest with you, I'm a little burned out on my board. I'm on 2 boards right now. And I think probably the best thing to do if you are experiencing board member burnout is, what are the signs first? Okay, so people are checking out, right? They're not coming to board meetings. They're not communicating. Maybe they're dropping the ball on things they said that they would do, just not motivated, just not contributing anymore. Now, I think my burnout is more that sometimes our meetings are too long, and sometimes I feel like we're not accomplishing anything. And it's frustrating for me to be on board when I feel like I'm giving of my time and I'm not seeing the results as fast as I would like to see things being improved in our community. A couple things you might want to do if you're feeling board member burnout in your community. What you might want to bring in our firm to help you with a boot camp and talk through the issues, right? Let's get everything on the table and let's talk through what are our problems, what do we need to do some planning for the future? Are there personality conflicts? How can we set some goals for this year that we can, manageable, smart goals that we can achieve this year? And talk about board member expectations. And, hey, is somebody really so burned out that maybe it's time to resign and appoint somebody else new who might have some new energy to bring to the board? Keep an eye on that board member burnout and think about using the boot camp opportunity that I told you about. We've done a lot of them over the years and have really helped a lot of associations that might be struggling with any of these issues. Last but not least, we have a great cheat sheet on dealing with difficult people and harassment that I think would be helpful for your association if you have any difficult people situations, which most of our clients do. That's why we wrote the cheat sheet. We're going to be sharing that with you as well. Okay, so just a quick recap before we get into our 24 questions. We covered a lot of territory today. Actually, I think we covered more territory in this class than we probably cover in 4 classes normally. Just remember, as you're thinking about what are my responsibilities to the board, go back to this cheat sheet. It's very helpful. It contains great information for you and all the cheat sheets that we've shared with you today. Okay, let's talk about the questions. We have a lot of questions. It's 12:03 right now, so I'm just going to hop right into the questions. So the first question is, we are currently revising our 30-year-old CC&Rs. We are struggling with the section regarding eligible mortgage holders. We have reached out to our management company to see if we have ever in the past or present had eligible mortgage holders ask about voting or anything in our association. No one has answers. Are EMH, so eligible mortgage holder rights, still relevant after 30 years or at all? So this is something that was done in the 80s typically. It was written in the CC&Rs that eligible mortgage holders had to be notified if there was any change to the association documents. It's really not something that is ever used anymore in our industry, so you should be aware of that. But if you have it in your documents right now, you may need to comply with it until you amend your CC&Rs to get rid of it. The practical reality on this is that typically what eligible mortgage holders would need to approve an amendment to the CC&Rs, or maybe they can not approve it. And you have to provide notice to everybody who has a mortgage that's an eligible mortgage holder. You may have to comply with that to amend the document. So you want to get our firm involved and help you with this process and help you navigate what you do and don't have to do to comply with that. Okay, next question is from an owner. Can the board or management company add attorney's fees on a homeowner ledger when a lawsuit has not been filed? I had attorney's fees added to my ledger for a law firm letter written to me in regards to an alleged non-compliance. And it says parentheses with no CC&R rules regarding the offense. So, it really just depends. It depends on what your CC&Rs say. Do your CC&Rs, allow the association to charge an owner for enforcement of the documents? Most do, and I think my best advice to you here would be time to reach out to the association and try to talk about this issue and resolve it before the attorney's fees get any higher. Okay, next question. Our bylaws call for 5 directors. We recently had 2 directors resign. Does it still require the 3 remaining directors to carry a vote or form a quorum? Or can 2 of the 3 create a quorum? So you had 5. You're down to 3 now because 2 people resigned. So 3 is a quorum. You can still conduct business. So 2 out of the 3 can make decisions. But all 3 of you need to be present at every meeting in order for there to be a quorum. Next question, number 4. Do you believe that obtaining animal DNA is a good way to detour problems with poor pet owners? Okay, so this is actually really kind of a good question. I love this. Okay, so the DNA testing is for like animal feces, right? And if we have owners that aren't picking up animal feces, sometimes boards talk about, I've actually never had a board do this. I've seen a lot of articles about this, and I've had this question a lot, but I don't actually have any active board member that's doing doggy DNA. I mean, I just don't think it's that practical. I have a dog. I walk our dog 3 times a day. And I see pet owners that don't pick up after their pets, and it's annoying, but I just get an extra bag and I usually pick it up myself and just throw it in the trash can. The problem with doggy DNA is that all the good dog owners, like us, right, myself included, are going to take our dog in there and get them, the DNA done, right? But the dog owners that don't go in and register their dog, they're never going to go in and get the doggy DNA kit. So when we spend the money to send the feces to wherever to see whose dog it is, we're going to turn up as nobody because these are the type of people that don't register their dogs. So in theory, I think it sounds great. Like, oh, we're going to bust people on not picking up after their pets by, doing this doggy DNA thing. But the reality is it's probably not going to work. The better thing to do would be to continue to educate your owners about the importance of doing this. Have your landscaping crew and any other people that are doing inspections at your property, look for animal feces. And if it isn't picked up, they should pick it up. Now, if you see somebody, if you have a direct report that somebody's not picking up after their pet, then you should treat it as a violation and send them a letter and fine them. Okay, number 5, can we as a board prohibit the new fiber optics company in the community? Probably not. And that's kind of a loaded open question, but I don't think that usually there are easements that are on your plat map that would allow them to install fiber optics, but it's a case-by-case basis. Now, I'm guessing the reason why you want to prohibit them is because possibly they may be tearing up your roads or whatever. They have to put it back exactly the way they found it. So if you have a company that's coming in like Cox or anybody, and they don't put things back to exactly the way they were before they came in and installed something, we can require them to come back and do that. Question number 6. A shed which was installed by a prior owner on a lot has been argued by some as being in violation of the governing documents. ARC application was never submitted. The board has not ever taken any action. How long after a violation has occurred can a board delay requiring remedy of the violation before such remedy becomes unenforceable in the eyes of the law? I would say if it's been there for more than 3 years, forget it. You're not going to be able to enforce it because there's a waiver. We didn't enforce it against that person. Also, you said prior owner. So why wasn't this picked up at the sale? That would have been the best time to pick it up, the violation, and notify the buyer of the shed being in violation at the time of the sale. Okay, number 7, our master board has removed historical financial information from our website, annual audits, annual budgets, and past reserve studies. They also removed selected, approved, open meeting minutes. Is this legal? I don't know. I mean, are they doing some housekeeping because there's just too much stuff on there? I think that's totally fine. Is there a reason? I'm guessing there probably is. So maybe what you might want to do is just ask. You don't want to have too much stuff on there if it's becoming too overloaded. So I get that. I mean, I totally get that. So is it like a intentional, like deep fake or deep dark state type thing? I doubt it. But it could be. So I would just ask some questions. And if there's something that you're looking for, you always can make a record request too. So is that legal? Yes, they have the right to regulate what's on the association's website. Okay, next question, number 8. Our board approves a new budget every October. We have line items for plants and trees. How is this typically used by the board? Does the landscaping committee typically get access to this? I know it depends, but what is typical? So it is not typical to have a line item on the budget for plants and trees. In my experience, maybe there's a landscaping budget, or something like that. It's typically in the discretion of the board. I'm thinking about my association. We have a line item to use money for something dies, to replace it, or to upgrade, and the board makes the final call on how that money is spent. Typically, when you say, how is it used by the board? It's used as needed. Does the committee get access to this money? Usually not. They can make recommendations, but the board's ultimately the one that makes the final decision. Question 9, is it okay for a board member to hold 2 positions, such as president and treasurer, because we cannot get 2 people to accept the responsibilities? So if your bylaws don't prohibit, that's fine. The only thing I would say is president and treasurer, that's 2 big jobs for one person. I'm not saying they can't do it if it's not prohibited by your documents, but that's a lot. What you might want to do is do like president and secretary, or treasurer and secretary, versus, 2 sandbags that are heavy, president and treasurer. Those are pretty hard to do at the same time. Okay, next question, number 10. What is the legal authority or pushback HOAs have on enforcing street parking restrictions? This is a non-gated community built prior to 2015 that does have street parking restrictions in the CC&Rs. So we have a great blog that we're going to be sharing with you on parking violations in an HOA or condo. So if your community is non-gated, built prior to 2015, I don't know if it is the streets are dedicated to the city or not, but I'm assuming that they are. And you have street parking restrictions stated in your CC&Rs. So there's a law that went into effect last year that talks about an association's ability, a planned community's ability to enforce on-street parking if the streets are dedicated to the city. The legal authority is right now, you can continue to enforce the parking restrictions. But in 2026, if your board wants to continue that, if the streets are dedicated to the public, you're going to have a vote of the membership to keep doing that before this certain date in 2026. You may want to check out our cheat sheet on the legislative update from last year, 2023, for more information on that law. Okay, next question, number 11. Can the board meet officially or unofficially to discuss and gather info on an issue such as changing gate codes, updating the CC&Rs? After discussion and gathering info by the board, we would then discuss at an official meeting with the community. Okay, so the question is, can the board just meet to discuss information like on gate codes, updating the CC&Rs, and then take it to an official meeting? So yes, but it has to be less than a quorum. If you don't want to notice the meeting as an official or unofficial meeting, it only can be less than a quorum to not violate the law. If you want to do it with a quorum, then you just notice it as an official meeting. Question 12, all of our condominiums have a garage, which is the most convenient place to park to access our condos. We have some visitor-only parking and some parking open to residents and visitors. Some handicap spaces are in the visitor-only areas. Can we ask residents to not park in the visitor-only handicap spaces because their garage is the best accommodating place to park? This is like a loaded question because I'm assuming that you have a handicapped resident that's parking in the handicapped space, and that is something that I think is going to be okay and that you can't prohibit. So I think on this one, if you're going to enforce it, you definitely should reach out to our firm to discuss it further, give us more facts. But I think in this case, based on the limited facts I have, I would not go there. I would not tell that handicapped person to not park in the handicapped space in the visitor parking. Okay, question number 13. In regards to executive meetings, a resident lawyer has started legal action against us, and he feels that we should disclose everything that is discussed in executive session. We have sent redacted minutes, but he still wants more. What, if anything, are we required to allow this resident to see? It's always fun to have lawyers in your community, right? Who are, saying that they, know the law and are going to sue you. Okay, so you really shouldn't be disclosing everything that is discussed in executive session. You have no responsibility to do that. As long as you're focused on the executive session topics and you're not going off on other topics, he can't have any discussions from the executive session. So That's the bottom line. Even though he's a lawyer, even though he's threatening to sue you, as long as you're following the law and talking about executive session topics in executive session, you don't have to give that person anything. Okay, next question, number 14, from one of my favorite clients in the West Valley. Does an HOA board have a responsibility or obligation to represent homeowners in matters of concern that originate beyond the property boundary of the community? Example would be homeowner concerns about possible crime from a proposed convenience store whose building permit is under consideration by the city, or homeowner complains about an unpleasant owner whose source is believed to be a milk processing plant in an industrial zoned area, or homeowner complaints about road noise from a nearby multi-lane highway. All these issues are regulated by federal, state, county, or city government agencies to which any citizen can express his or her concern. But does the HOA board have the duty to be the principal champion for association members in these types of outside the walls matters? So I would say no, the board does not have the responsibility or obligation to get involved in really any of the examples that you've given me. However, there are times where maybe the board would get involved, but you don't have to. Okay, so for example, let's say that, I've seen some boards get involved. Let's say that maybe the board doesn't want a certain thing to go in and there's some public feedback, that's allowed at city council or something. I mean, some examples I can think of is back when marijuana became legalized in Arizona, for a lot of associations didn't want to have these medical marijuana dispensaries. Maybe the board was sending a letter if there was like a lot of smoking or something and to the owner of the facility. But you're not obligated to do it. And I think what you can do is encourage them to, band together with other residents. And if the board is in favor of it, you can also sign off on it. Like, hey, we think there is an unpleasant owner, but you're not required to. I think that's the most important thing. And remember, if you're looking at what you're required to do, you look at the CC&Rs, you look at state law, and state law doesn't require you to get involved in any of these things. Next question, number 15. I know that towns do not have to follow state or federal guidelines. Wish I would have realized that before now. So what can be done when HOAs inflict horrible CC&Rs? Move. That's one option. Run for the board. See if you can make positive change from the inside. Try to get an amendment passed to the CC&Rs that you don't like. Okay, question 16. Our bylaws are silent on ballots. Our community has had open ballots since its inception. We wish to change the ballot procedure to make it a closed or private ballot, secret ballot. Given the bylaws are silent, can our association change to closed ballots without a vote of the membership? For example, can we simply clarify closed ballots in the same way we clarify rules without a member vote? One thing that I'm going to say, I don't know why you want to go to a secret ballot, but it is kind of a hassle. And lots of times homeowners don't understand the concept of a secret ballot and they write their name on the ballot, which could potentially invalidate it. And it makes it more difficult for people to vote, or it's supposed to be a double envelope system with a secret ballot, and, they don't follow the directions and end up spoiling a lot of ballots. I guess your board could say that they want to have it be secret ballot, but unless it's in your bylaws saying that you have to do it, an owner could say, no, I'm not complying with that. I'm going to write my name on it, and there's not much you can do about it. I don't really think secret ballot's a good thing, so I wouldn't encourage you to do this. And second, if the board wants to do it anyways, you certainly have the right to set up the ballot that way. But if somebody doesn't want to comply, there's not much you can do about it unless you amend your bylaws to change it. Okay, question 17 from a manager. I have a new board member who continues to take photos of a homeowner's children, even if they're just playing on the sidewalks. They have not done any damage to the common area, but they do play outside a lot. He takes pictures and posts them to a Facebook page that he runs for the community. He has also banned this homeowner from the Facebook page. He's new, so I'm trying to educate him. I used your cheat sheet regarding social media, so thank you. That's nice. But am I correct in thinking that this may open the association to possible harassment issue if he continues to do this? Yes, this is problematic in many different ways. Okay, A, he shouldn't be taking pictures of children and putting them on social media. That is a big no-no. Second thing is he running the Facebook page for the community? That concerns me right there, because you guys should have some sort of policies and procedures as to what can and can't be put on there. And I don't think putting those on the Facebook page for the association or any Facebook page saying, hey, these kids are violating type of thing is a good idea. The better way to handle that would be to contact the parents. But I mean, again, like, kids are kids, they're allowed to play. So I haven't heard anything about them playing on the sidewalk. Yeah, I think that we need to give some education to this person about, hey, you can't do this, and give them some guidelines as to what can be posted. Okay, question number 18. Our CCNRs state garbage and refuse facilities, containers, and the like shall be attractively screened and camouflaged in such manner as to conceal them from the view of neighboring lots, residential units, property, roads, or street. Our landscapers recently trimmed some screening bushes such that several refuse containers are now visible. Some of our members received violation notices as a result of the trimming and are contesting the violations. Should the association waive or not violate members in this situation? I guess the question I have for you is the screening of the trash cans, is it common that it's by bushes and trees or whatever, and the trees are going to grow back? So I was thinking more that it would be like screening and camouflage would be more like building a wall around it. So you probably know the answer to that better than I do. If the screening and camouflaging that's, allowed is to have trees and bushes or whatever, then they're going to grow back. I probably would not violate them. But if this is the type of thing where maybe you had some overgrowth and they were using it to camouflage it, but really they should have been building a wall around it or something, then you may not want to waive it. Okay, question number 19. If a property management hasn't required previous board to enforce CCNRs in regard to exterior architectural changes, and the new board is noticing changes made but owners hadn't requested nor received architectural approval, what can be done now that a change is complete? I mean, you can send a violation letter. You can work with the homeowner to try to fix it so that it would be approved. You should be reminding your homeowners now in advance through frequent communications like, hey, no changes, no architectural changes without getting approval first. So on the person that's already done it, open lines of communication, maybe send them a letter, see if you can work it out with them amicably. I don't know how serious the change was, but you might be able to go the legal route. Although I don't know, because you haven't enforced it in the past. We have to weigh a lot of different things. Question 20. A member of our 3-member board is somehow under the impression that if all 3 of our board members vote to approve a proposal by email, then we do not need to otherwise follow the dictates of the open meeting state statute, announcing a meeting 72 hours in advance, etc. Okay, that should be 48 hours. Unanimous approval via email is somehow a special way to gain board approval outside of a regular meeting. I have never found such an exception in state statutes. Please clarify. Okay, so I am in agreement with you that using email to make decisions outside of a board meeting is a violation of the open meeting law. There are some exceptions. If it's an emergency, I think you can use an email to make a decision. But I know a lot of management companies are saying, hey, this is okay because it's in the Nonprofit Corporation Act. You can make decisions by unanimous written consent, but it directly conflicts with state law because open meeting law says you have to make decisions in a board meeting. And there's at least 1 or 2 administrative law decisions that say you can't make decisions via unanimous written consent. So I would shy away from that practice. I think it does violate the law. Question 21. Are associations required to provide to homeowner information such as violation, fine, account information of other homeowners? So what the law says is that we can withhold from discovery, so we can withhold information that might contain personal information about an owner, or if we're involved in a lawsuit with the owner. So I don't know, based on the facts here, I don't think, that the violations and fines it could be considered personal information, although it may not be. It doesn't sound like there's a lawsuit here either. So here's kind of my golden rule. So I'm fine with you sharing information about what's in the file, right? So if you've got letters in the file that might be violations or fines, I'm fine with you sharing that. I'm not okay with account information. So social security number, bank account numbers, phone numbers that might be like cell phone numbers, personal emails. I'm not okay with that because I do think that's personal information. You cannot give that to the other side. I would probably, if I were advising your board, I would push back at first and say, no, you can't have this information pursuant to state law. If they push back and say, well, I think we can have maybe like what the content of the file that's not personal information, then you may have to provide that. Okay, question 22. Who should approve the annual meeting minutes? The owners at the next annual meeting or the board at their next meeting? So annual meeting minutes are approved annually. So the next annual meeting, you will approve those annual meeting minutes from 2014. You'll approve those at the 2015 annual meeting. Now, the board may want to take a spin and look at them right after the annual meeting, just look at a draft, but they're not voting on them. Question 23. As a new board member, other than your website, are there any other things that I should read? Is there a good book or a good website? I would look at the Community Associations Institute national website. Just type in Google CAI or Community Associations Institute and make sure that you get the national one because they have a whole bunch of resources there. I think that would be the other place that I would go to. Question 24. If a board has D&O coverage and a majority of the board agrees not to enforce most of the CC&Rs and rules, like parking, styles of vehicles not permitted, trash can, short-term rentals, does the D&O continue to cover all board members if an owner sues an association and or board members individually? Should this board decision be a formal vote and an executive or open meeting? Okay, so your D&O coverage is probably going to be covered on something like this, whether the board's making a mistake and not enforcing it or whatever. So you're probably going to have D&O coverage no matter what. But what I don't like here is taking a formal vote saying we're not going to be enforcing our CC&Rs because you really shouldn't be doing that. You should be changing your CC&Rs if you don't want to enforce them. Okay, question 25. Should board members provide their board email to community members, or should all communications flow through the property manager? It really depends on how, in my opinion, how the board wants to run it. I don't think there's a correct answer. Sometimes the president puts their email out there. Sometimes they don't. If you put your email out there as the president, you're going to have a lot of emails. And some presidents are okay with that. Most of our clients just have the management company email. Okay, last 3 questions. There is a solid case regarding fair housing violation against our HOA. If the AG brings a lawsuit against the association, what kind of impacts may the 16 owners in our community face? That worries me. It's a concern. If there's a solid fair housing violation case, you should try to settle that. The AG's office typically engages in conciliation, which is like a mediation through the AG's office. And you should resolve it and apologize. If let's say that you don't, and this continues to escalate and they file a lawsuit and now you get a judgment against you, it may or may not be covered by the insurance. So if it's not covered, then take whatever the expense is and divide it by the number of homeowners and you may have to pay your fair share, which is scary. So I hope it doesn't get to that point. Try to resolve that. Last 2 questions. 27. What financial information should be made available to community members beyond the balance sheet and income statements? So when you say shall be made available, like on a monthly basis, are you saying, or like if they request it? Honestly, I would just put the balance sheet and the income statements on the website. And if somebody wants more, like they want to see a bank statement or they want to see the year-to-date budget or something, then provide it to them. Last question. At our recent annual election, a board member candidate posted a bogus message on social media telling residents that they could change their vote if they wanted by picking up a paper ballot at the office and dropping off the ballot in the ballot box. As a resident of Maricopa County, I'm a little sensitive to any type of election disruption for any election. What is the recourse for the board on this issue? I don't know. It's problematic, but if your ballot, like the ballot that I write for associations, it says right on the face of the ballot, this is non-revocable. So if you have that, or irrevocable, which means that even if they cast a second ballot, it wouldn't have been counted. I think probably I would talk about this as a board and just remind everybody that like, hey, you shouldn't be doing stuff like this. And of course, this person was a candidate at that time, but explain to them that, the ballot is typically irrevocable. So by putting that information out there, it just created confusion and more work for everybody. So it wasn't a good thing to do and they shouldn't have done that. But people are weird and sometimes they do it no matter what. So even you may tell them not to do it, they continue to do it. Just know your rights on the ballot. Which one should be counted is the one that's stated first. Okay, we are at that time where we're at the conclusion. We covered a lot of ground today. So thank you so much for being here. Many more on Facebook Live. Thank you again for joining us today. And I'd like to give a special shout out to the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe for their continued partnership. And a high five for you guys getting a representative, or at least some representatives from each city here today, which is awesome. Our firm recently released the class topics for July through December 2024 for our virtual HOA Condo Academy classes. We have those all posted on our website now, so we're just going to keep on moving forward. Don't forget, our next live virtual First Friday event is set for Friday, June 7th at 9 a.m. And we'll be getting online on Zoom and Facebook Live at 9 a.m. on June 7th and answering your questions regarding HOAs and condominium law. Next month, we have our 6th class of 2024 for the virtual HOA Condo Academy is set for Tuesday, June 18th at 11 a.m. The topic for next month's class is going to be Untangling the Web, Navigating Politics, and Frequently Asked Questions in HOAs and Condos. So I hope that you will join us for this class. It's going to be all about sticky situations, navigating politics, and how that all works in an association. And we're going to also address our firm's most frequently asked questions. So I hope you'll join us for that class on June 18th. Take care, everybody. Have a great rest of the month in May and look forward to seeing you at our future classes. Take care.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content of these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.